Your Honor, will note that this application has been brought under the ambits of Section 36A of the Criminal Procedure Code, which is a written statute. And as we all know, as lawyers and even students of the law in this courtroom, that statutes have their own ways of interpretation.
Yes.
And, Your Honor, to discourage this sort of mischief, the Parliament, in its own wisdom, brought into force the Interpretation of General Provisions Act. And, Your Honor, Section 57D.
Serial number?
Section 57D.
Okay.
It states that where an act or proceeding is directed or allowed to be done or taken within any time not exceeding 6 days, excluded days shall not be reckoned in the computation of time. The excluded days are Sundays and public holidays. That is if the prayer or any request is made where computation of time is required for less than 6 days. You're not asking for 21 working days. That is well over the 6 days which are provided. And Your Honor will note that this question was addressed in the case of Longinus Oroni Murunga versus David Masika Matumbo, Civil Appeal number 319 of 2013, in the Court of Appeal at Eldoret. And Your Honor, paragraph 12 of that decision goes on to explain, so that for the benefit of the applicant, they do not perhaps wish to proceed with this mistake in another case, that the section 57D is very clear, and in fact it goes in tandem with Article 259(6) of the Constitution in terms of computation of time. Therefore, it is my submission that the application as framed, we are all aware that we are bound by our pleadings. That the orders cannot be granted. As such, the application is incompetent. And the respondent should be released forthwith. That's all, Your Honor.
Right.
Your Honor, may I?
Oh, you want to say something?
Yes, Your Honor, let me say something.
Can you remind me your name?
Yes, Mr. Sophie Nekesa, Your Honor.
Okay.
I will be very brief, Your Honor. I want to deal with the applicant's reasons for detention. As defined from paragraphs 31, from paragraphs 24 up to paragraph 31. Your Honor, those are the reasons the applicant has put forth to this court as for the reasons for the need to detain the respondent herein. Your Honor, my submission is that all those reasons listed from paragraph 24 to paragraph 31, for all those reasons that they have listed, they do not need the respondent for that. Your Honor, this matter or rather, my submissions are based on the authority which I have served the DPP. Betty Jemtai, this is a miscellaneous criminal application. Betty Jemtai Kimeyo versus the Republic. This is a miscellaneous criminal application number 26 of 2018. There are three things, or rather three important action points that I wish to address from this authority.
Yes.
Miscellaneous criminal application number 26 of 2018. Date. So you're paragraph 7 of that authority. The court is saying the respondent can be detained based on available evidence. Available evidence are the wordings of that paragraph, Your Honor. It has already been shown from the supporting affidavit of the applicant. No evidence has been shown to this court, and therefore they are mere averments. It has not been shown, Your Honor, paragraph 9 of that authority, the reason as to why the respondent might be detained further. The prosecution needs to show that the suspect is a flight risk or is likely to escape or is likely to interfere with the witnesses. Your Honor, even from the supporting affidavit of the applicant, they have not averred to that effect. There is nowhere the applicant is saying the respondent is a flight risk or is likely to escape. And number one reason why the respondent is not a flight risk, why he is not likely to escape, and why they did not put that in their supporting affidavit is because the respondent is a serving police officer, Your Honor. He cannot escape and leave his job. That is what he does for a living. That is what sustains him and his family. There are averments to the effect that the respondent might interfere with witnesses. Your Honor, paragraph 3 of the supporting affidavit of the applicant. The applicant says they have already interrogated some witnesses. So when at paragraph 30 they say they will already interfere with witnesses, we are wondering if who are these witnesses that are yet to be interrogated? Because at one point they will interfere with the witnesses, at another point we have interrogated the witnesses. So where is the truth? If anything, Your Honor, this is a police corporal. Constable, apologies, Your Honor, is a police constable. It cannot be true when the applicant says he is a police officer. That is paragraph 32 of the supporting of affidavit. It cannot be said that the police officer wields police powers. A police constable, Your Honor, is not capable of wielding any police powers in the context of these investigations. So, Your Honor, if we read the supporting affidavit from paragraph 15 all the way to paragraph 22, Your Honor, the applicant is saying the respondent is likely to. There is a likelihood the respondent will. There is a likelihood the respondent did. Your Honor, that just goes on to show that there is no evidence. Like my senior put it, they are mere apprehensions. There is no any evidence whatsoever that has been brought to this court to support the averments, and therefore they are mere statements which cannot be proved. So the conclusion of that authority, that is paragraph 14, and this is the action of this authority, Your Honor. I do not find that the police offer good reasons for the continued detention of the arrested person, because the matters they used to justify the detention, taking witness statements, obtaining call data, securing forensic reports, those are things that can be accomplished by the applicant without the physical need for the respondent. And that is why, Your Honor, we are asking that the application be disallowed, because the respondent is not physically needed for the applicant to carry out his duties. Now, Your Honor, there is a test that was established in the celebrated case of Oscar Sudi that my senior briefly touched on. This is Sudi Oscar Kipchumba versus the Republic. It's a criminal revision number 208 of 2020. Your Honor, in this case, there's established a double test that must be passed by the applicants for them to be able to detain the respondent. And these are the two tests, Your Honor. Number one is that there must exist exceptional circumstances. Exceptional circumstances for the applicant to want to detain the respondent. Your Honor, you have been told there are other people that are yet to be arrested. There is suspicion that other people were involved. From the deponent's own avowals, when he was here, he said some of the people are policemen and some are not policemen. If there are people who are involved together with the respondent, Your Honor, and they are not here, we do not know the extent of their involvement in this matter. So why would it be that the detention of the respondent is exceptional? Our submission on that, Your Honor, is that it is not an exceptional circumstance to want to detain the respondent. Number two, Your Honor, the second limb of the double test is the need for the applicant to use the least restrictive means. Least restrictive means. Your Honor, detention of the respondents cannot be said to be the least restrictive means for the applicant to be able to conclude their investigations. These courts can release the respondents on reasonable cash or bond terms and impose conditions that will enable him to attend the court. This court can impose a condition that the respondent should not leave the court's jurisdiction, that the respondent should be able to respond to the IO or any investigator whenever he is called upon. It cannot be said that the only way for the investigations to be carried out is detention of the respondents. Your Honor, those are my brief submissions on the matter, and for that reason, we pray that the application be disallowed, the application by the applicant be disallowed, and the respondent be released on reasonable bond terms or cash bail terms. Thank you, Your Honor.
One word before, because we will not have time to do any submission. I apologize. My client tells me he had told me to pass his sincere condolences to the family of the loss of the deceased. He's a human being, and any family that has lost anybody is a big disaster to that family. And on behalf of his defense team, we also pass our condolences to the bereaved family and may God give them grace as they deal with this sudden death. That's all, Your Honor.
Okay. Prosecutor, do you have something to say on the response to what
Yes, may it please Your Honor, my name is Okundo. Your Honor, so we are both the applicant and the respondent at the same time, so I'll take it globally in my response.
you are here for the state?
Yes. Yes. For the state.
Okay. Proceed.
I'm a prosecutor.
Okay.
Your Honor, we humbly submit that the evidence which has been tabled before you in the form of a affidavit clearly lays bare the reasons as to why the respondent should be detained for the period that has been requested. The circumstances leading to the investigation by all is not in dispute. And this has been categorically stated in the affidavit. There is no dispute that life was lost. There is no dispute that the deceased died in a police cell at Central Police Station, to be specific. And this was confirmed by the medical report which has been attached to the affidavit. And the OB extract which have been attached, which clearly demonstrate that the deceased was removed from the police cell, taken to Bangati Hospital, where he was proved to be dead. There is no intervening incident. There is nothing which intervened which could say that the deceased did not die out of the cell. That is clearly demonstrated. It has also been demonstrated in the affidavit that the respondent is the one who was manning the sentry at the time. There was no any other person. That has not even been disputed. And the key reasons, which are the key grounds why this application has been made, is that there is fear of interference with witnesses. And the reasons have been given in the affidavit, which clearly demonstrate that this officer, the respondent, is likely to interfere with witnesses whose statements are necessary and who are police officers. Your Honor, it's our humble submission that when it comes to the issue of rank, that's not what counts when it comes to interference with the witness. Interference can take any form, any shape. You don't have to have influence or bear any influence. Your Honor, it has also been submitted before you. It has also been laid bare in the affidavit that the nature of the investigations are complex. And, Your Honor, this court, and it has been decided in several cases, when the courts can consider granting such application. And this, I'll enumerate them. We'll give authorities, I'll give the citation. One is the serious nature of the offense, which is under investigation. The second ground is early and sensitive stage of investigations. The third issue is the forensic and surveillance-based complexity of the case. And finally, risk of interference with an ongoing inquiry. The facts which have been imposed in the affidavit clearly demonstrate the four grounds which I've stated. Your Honor, it has been submitted that the arrest of the respondent was a knee-jerk reaction. We submit it was not. It has been established as to when investigation in this matter began by I4. It did not begin yesterday. It did not begin with the arrest of the respondent. Your Honor, at this stage, with Article 49 of the Constitution and not Article 50. What Article 49 expects of the applicant in such a case is just to lay bare before the court the justification for continued detention of a suspect. We are not talking about the rights of an accused person who has already been arrested before the court, so as to apply the principles which are contained in the bail and bond, the guidelines which have been given. Your Honor, there are compelling reasons of the respondent detained to avoid interference with the investigation. Indeed, it is demonstrated in the affidavit that there was an attempt from the beginning, when it was realized that the theory of the suicide failed and it was established that the deceased was killed in a police cell, there was an attempt at interference or derailing the investigation from the beginning. And this has been demonstrated with attempts to destroy the data in the CCTVs. That is demonstrated, and it's not in. A person who from the beginning wants to destroy the evidence, that is a person who will go all the way to interfere with any kind of incriminating evidence which may be unearthed by the investigation. And this is not just a mere preemption. There is all the likelihood. It has been stated that there are other suspects who are, include even police officers, who are likely to be arrested. They are out there. There are people who are known to the respondent. It has been decided in the case which we cite that where a suspect is likely to be out and communicate with witnesses and even other suspects who are still on the run, he should be denied, he should be detained when investigations are ongoing. The investigation in this matter is still at very early stage. And it has been demonstrated how sensitive this matter is. Your Honor, we submit that there has been an attempt. It has been demonstrated that the investigating officers have been finding it difficult to retrieve information from the police officers. Requiring more reason why the suspect who is in custody should remain in custody for a few days, which have been requested. Your Honor, I want to respond to the authority which you are given. This is miscellaneous criminal application number 26 of 2018. This one of Betty Genitai, female applicant, versus party. At the onset, Your Honor, I wish to submit that this was an application dealing with the extension of time after an applicant has been detained. It does not apply to this instant case. Your Honor, we submit that there are justifiable reasons for continued detention of the respondent before the court. Article 24 of the Constitution allows for limitation of freedom. Regard only need to be given to the importance of that limitation. The importance of the limitation which we are seeking is to enable the investigation to be completed without interference. It will be total injustice, travesty justice, if investigation were interfered with. At the end of the day, there are no witnesses, there's no sufficient, there's no